On a Saturday afternoon, a police officer for defendant Town of Amherst, received a dispatch of customer trouble involving a white male patron at the bar intoxicated. Miller responded to the call by heading to the location of the bar with his emergency lights and siren activated. Miller's vehicle collided with a vehicle driven by plaintiff's decedent as he attempted to turn into a shopping plaza in front of Miller's vehicle. Decedent died as the result of the injuries that she sustained in that collision. We conclude that the Supreme Court erred in granting that part of the defendant's motion seeking summary judgment dismissing the complaint insofar as it seeks to impose liability on the town with respect to Miller's operation of the police vehicle. Although defendants met their initial burden on the motion, plaintiffs raised a triable issue of fact whether Miller agreed with reckless disregard for the safety of others in the operation of the police vehicle. Plaintiffs submitted evidence that Miller was traveling at a speed between 62 and 72 miles per hour. Miller's conduct exceeding the posted speed limit cannot alone constitute a predicate for liability, since it is expressly privileged under Vehicle and Traffic Law, Section 1101. Defendants acknowledged, however, that there was other vehicular traffic in the vicinity, and plaintiffs raised a triable issue of fact whether Miller was in violation of the rules and regulations of the town. Police Department, New York, 97. Plaintiffs' expert in the area of police vehicle operations and emergency responses opined that Miller's response and operation of the vehicle was in reckless disregard for the safety of others. We conclude, however, that the court properly granted that part of the defendant's motion seeking summary judgment dismissing the complaint insofar as it seeks to impose liability on the town based on the actions of the 9/11 complaint writer and the police dispatch. Defendants established as a matter of law that the determination of those individuals with respect to how much information to relay involved the exercise of discretion, and thus the town may not be held liable for the consequences of their determination. We therefore modify the order by denying defendant's motion in part and reinstating the complaint insofar as it seeks to impose liability on the town with respect to Miller's operation of the police vehicle. It is hereby ordered that the order and appeal be, and the same hereby is unanimously modified on the law by denying defendant's motion in part and reinstating the complaint insofar as it seeks to impose liability on defendant, Town of Amherst, with respect to defendant, and it must be a permit that is clearly permitted. In this case, Miller's operation of the police vehicle, and as modified, the order is affirmed without costs.